Breitenbach, a prominent Democratic Alliance DA member of parliament and a former senior state prosecutor for the NPA, had a sketching legal and political critique of this Vusimuzi cat Matlala plea bargaining that I spoke about in my last video. I'm going to play her shortly, but she's actually pointing out some of the key issues that I didn't talk about in the last video, which was this 8 reduced sentence. It's actually end up being a 3-year. And I'll come back why it will end up being a 3-year. Why was it published? The secret agreement, why was it made public before the judge signed off on it? They also pointed out, Breitenbach also pointed out that this was a procedural abnormality and heavily also critiqued the breach of protocol. Because under Section 105 of the CPA, these negotiations are meant to remain strictly between the state and the defense until they are formally presented to the court. In this case, these were made public. And Nkandla Mkhwanazi spoke about this last when he was commenting about this IDAC wanting the senior CI to come and present himself to the police station to be arrested, that they were actually going to prepare Matlala to go to the Matlanga Commission of Inquiry. Matlala was meant to go to Matlanga Commission of Inquiry. So IDAC went there to stop Matlala from presenting to Matlanga Commission of Inquiry. And I'll get to it. Why preventing Matlala to present to Matlanga Commission of Inquiry would have been a problem for IDAC, because they so desperately want Matlala to be a state witness, and they were willing to undermine judiciary by the separation of power, the judiciary's rights to review documents presented in front of them, to decide independently that whether or not they agree or not agree, by actually making this stuff publicly to all of us to read them. Because they shouldn't have done that. This was, she was saying, it was a joke. Like I said, this one is like, it's a hard pill to swallow, this one. And she spoke about it, why. And I'll play her right now so we listen to her argument. And I'll come back to why IDAC was so in a hurry to have Matlala to present this in public so it can prevent Matlala from going to Matlanga Commission of Inquiry. And it's got there's some legal issues if Matlala were to go there and then say things that, oh my goodness, that makes him contradict himself or incriminate him, then he's no longer going to be a credible witness. It's to do with witness credibility around this case. But it also, like I said, alluded to you that Matlala, there are other things that came out that implicate Matlala around this drug trafficking, international drug trafficking that came out around Matlala and his partner in crime, Mike Van Wyk. So that also is still another offense. It's another issue that it's implicate Matlala. And we haven't even touched the Tembisa Hospital saga. So this stuff here, it was so rushed that they were willing to break and to undermine judiciary by exposing this secret agreement before it was rubber stamped by the judge or magistrate. And that is the problem with IDAC. This is IDAC. Of course, this is IDAC. IDAC is part of the NPA. But yeah, this is IDAC. IDAC thinks they are law to themselves. I mean, you can work independently within the confine of the law, and you should not be acting in a manner that undermine other people from working independent. See, there they are now encroaching on judiciary, because judiciary now, the judge or magistrate will be forced to agree to this nonsense. Now that we know that this thing it's a horrible deal. Like I said, it's a hard pill to swallow, this one. But she actually explained it because she's a former prosecutor, so she knows, and we're going to give her a chance to explain this thing. So you guys listen to her argument, not just me, because she's an expert. She knows the stuff. Let's listen.
Bit more on that. Janice, good to have you. Thanks so much for your time. Under Section 105A of the Criminal Procedure Act, what is the exact legal mechanisms that allow us as the public to get these secret prosecutorial agreements before even the judge signs off on them?
Well, of course, that's good afternoon. It's not ideal that this thing was made public before the judge has even made it an order of court. It's deeply concerning that the document was available prior to it being made an order of court. But the machinations of the plea deal, of course, must belong to the NPA. They should know what they're doing, and they should negotiate a proper plea and sentence agreement in terms of Section 105A. But they should, at least at the end of this process, if and when it's made an order of court, be able to explain to the public why they entered into such a deal. And the public should know that a Section 105A plea and sentence agreement is not meant to be a soft option. It was never meant to be a soft option. And it's not meant to be an easy way out or an easy way of getting rid of long and difficult cases. Section 105A is there for people who genuinely show remorse and want to plead guilty, for people who understand that their backs are against the wall and they have nowhere to go because the state has a watertight case. And then it's there for people like Mr. Matlala, who want to try and save their own skins by shopping their friends in crime and try and get an easier deal for himself while he gives up all the other criminals that he's involved with. So those are the instances in which you use Section 105A. But that still doesn't mean that it should be a slap on the wrist. And the sentence that is currently suggested by the National Prosecuting Authority is a joke. It is nothing but a slap on the wrist.
Now, the NPA says they must keep their affidavits secret. Now, being a former prosecutor yourself, how can you make a demand for full disclosure without completely blowing maybe a major ongoing criminal investigation?
We're not asking for them to disclose their affidavits. Of course, their affidavits must be kept secret. No prosecutor would ever publicize or give out information from their affidavits. They certainly would never do that, and nobody would ever ask them to, and that's not what we're asking. We're saying this plea deal is a very, very light sentence.
Yeah.
Mr. Matlala is looking at 15 years, where effectively for the offences that he's been charged with, he should be looking at 150 years. So he's looking at 15 years, of which 7 is suspended. That means he goes to prison for 8, which means he will, in 3 years' time, qualify to have his sentence converted into correctional supervision, which means he goes home. But they don't tell the public that.
Yeah.
They don't tell the public that this plea deal doesn't mean 8 years in prison. It means at the very most 3 years in prison. And then the plea deal is set up in such a way that if he doesn't give them the evidence that they want, or if he doesn't testify against his former cronies, then the suspended sentence portion comes into effect. Well, you can't contract like that, I'm afraid. It's not how plea and sentence agreements work. The document is poorly drafted. It is not clear. And so the NPA should give clarity on why the document looks like it looks, whether they have considered all the contingent problems that will arise as a result of this document. And they should be quite clear that when they say to people that he will go to prison for 8 years, that is in fact not the case.
So let's talk about the power here. I mean, the NDPP seems to have massive constitutional discretion to cut these deals. Does Parliament, can you as parliamentarians jump in here? Do you have real teeth here to be able to oversee these backroom negotiations?
No, of course not. The National Prosecuting Authority is an independent institution, and it should be. And nobody can interfere with this, and Parliament doesn't seek to interfere with it, and neither do I. What I seek is a full disclosure on whether or not they have considered all the ramifications of what I view as a poorly drafted document, and whether they are willing to tell the public the truth. That we're not looking at 8 years, we're looking at 3. For fraud, corruption, and money laundering charges that range in the upper 50 million range. In fact, 250 million range. That is not a sentence for that kind of an offence. It's a joke.
Glenys call it a joke. So it's a joke. This is a South African thing, correctional services law. So under South African correctional services law, say for example, Matlala, bare minimum is 15 years. And then this now has been this deal, closed door deal that hasn't been rubber stamped by any judge or any magistrate, has given a suspended sentences portion to 7 years, meaning that Matlala could serve about 7 years active in prison for this commercial crime. This doesn't include other crimes that he's facing. All right, so under this correctional services law, an inmate sentenced to a fixed term of direct imprisonment for non-violent commercial offenses. It's a commercial offense. It's the non-violent commercial offense can apply to have their sentence converted into a serving a minimum portion. Often it's 1/3, so it's like 7 or 8 divided by 3. Then you get about 2.6 to about 3 years. That's why Glenys is saying this is a slap on the wrist, and I agree. 3 years behind bars. When Glenys is saying it should have been around 150 years, meaning dying in jail in this one for these type of offense. I mean, we're not even looking at the other criminal offense that he's facing. And she also highlighted this, the sloppy drafting, the sloppy drafting, legal drafting of this document. The sloppy drafting here is that I actually saw that, but this is a problem. That if Matlala, the NPA, the IDAC, under this IDAC thinks they are law to themselves. They said, if Matlala doesn't perform well as a Section 205 witness, the 7-year suspended sentence automatically kicks in. And as she's a seasoned prosecutor, that she said, you can't contract like that. You can't make such a contract like that because the enforcement of a suspended sentence requires a formal independent court inquiry. So it requires a judge where a future judiciary officer then will then have to review these breaches that is being alleged by maybe somebody, police or whoever. But you cannot really draft like that. So the NPA or the IDAC here, this is IDAC, cannot legally write a clause that bypasses future judiciary discretion or binds the hands of another court based on the vague terms of satisfactory evidence. As she labeled it, like it was poorly drafted and not clear. Well, it's a sloppy legal draft. It's a sloppy legal draft that actually encroached on other independence of judiciary, on the independence of judiciary. This even the drafting itself, it's sloppy enough. It's encroached on the independence of judiciary. The release of these documents before the judge, rubber stamp or magistrate, rubber stamp them. It's also another problem on itself. That now IDAC, it's a law to themselves now. They're now a court system, IDAC. Not only are they prosecuting, they're now becoming judges and magistrate. This is horrible. Like I said, IDAC needs to be disbanded immediately. We can't have something like this happening again with IDAC. This is the reason for this stuff. Like I said, they wanted to prevent Matlala from going to the Commission of Inquiry, Matlanga Commission of Inquiry. The problem with IDAC, the reason why IDAC did this, is Matlala had testified. He would have been forced to answer questions about international drug cartels, metropolis hijacking syndicates, and cash hands off of two national politicians. So IDAC intervened because if Matlala implicated himself in an international drug trafficking or high level political bribery on a live broadcast before signing his Section 105A plea deal, his legal credibility as a state witness would have been instantly destroyed. The defense lawyers for those 16 officials that are implicated in this would have torn him to shreds in a criminal trial. So this is the reason why IDAC ran quicker to ensure that they close off Matlala's affidavit. Yes. So, but this is exactly why Clarence Breitenberg and the public are treating this entire plea deal as an institutional joke. It is an institutional joke. It gives the illusion of a massive, successful anti-corruption swap because a sitting national police commissioner and a dozen generals are in the door. But in reality, it's a highly calculated damage control operation. The state is allowing a cartel mastermind to buy his way out of multiple decades prison sentence for his financial crimes by trading the identities of a few crooks cops, while his deeper roles in violent assassination plots, hospital looting, and international drug trafficking are pushed entirely into the background. That is the problem. Because we also know that Matlala is also implicated in this Suleiman Karim. Suleiman Karim has been avoiding to come to the Matlala Commission, giving all sorts of excuses. Last time, apparently, he was claiming sick again. You know, every time these people are implicated, they have an illness called Matlanga Commission of Inquiry illness that just come up as soon as they're asked to come. Okay, even Van Wyk was the same thing. Van Wyk and Van Wyk, Michael Van Wyk, his testimony was actually read out. So I think the commission, they'll have to think about doing the same what they've done with Mike Van Wyk, Van Wyk around what are the things the commission has against Suleiman Karim. Because it looks like Suleiman Karim actually has been actually obstructing the Matlanga Commission because he hasn't even provided the documents that the Matlanga Commission of Inquiry requested him to provide around his company. And we all know that Suleiman Karim is linked to Vusimuzi Matlala because we know from the transaction logs that prove that Matlala was running a massive layered financial networks. So Suleiman Karim admitted to advancing 10 million rand to Matlala's Medicare 24 vehicle under a loan agreement tied to this SAPS contract, 280 million rand SAPS contract, only to be caught in a web of misdirection, political name dropping, and suspicious fund transfer. Crucially, though, a third of that money flowed back to Cyril Ramaphosa, the president's nephew, Morgan Maumela, linking the substandard directly to Tembisa Hospital looting network. So we have a group of people that should be in lockup forever. Should not, for me, Matlala should not have any plea and sentences agreement whatsoever because there's so many stuff against him. Like Dennis said, you cannot, have a quick make a quick meal for something like this, a case like this, and try to create these backdoor deals for someone like Matlala. It just cannot be. So hey, yeah, that's what I said. This IDAC, anti-corruption, what, it's not anti-corruption, this thing. It's actually releasing criminals into community that should be locked up forever. What I'm looking at it here for IDAC, because this is their case really. It's just so horrible. Anyway, yeah, the issue here that Matlala is that Matlala still has some stuff that implicate him, and Matlala Commission of Inquiry is not finished. And this Matlala Commission of Inquiry needs to be extended. We can't have a commission of inquiry that's a few months that is dealing with so many stuff. It should be extended for another 2 years, if you ask me, because we have a lot of stuff. They have a lot of stuff to go through, and you have people that actually do not want to come for reasons that are not justifiable, and they need to be laid out there. But the politicians, the ANC specifically, don't want to fund it. But quickly, we managed to have 600 million for this security for 30th of June. That nobody knows what's going to happen for 30th of June, if you ask me. But they were able to come up with that. But they can't come up with extension of Matlala Commission of Inquiry. When we're seeing people avoiding to come because they are part of this network, and you cannot end this stuff if you're not committed to it. You cannot end it. You need to be committed to stop criminals. ANC, the GNU is not serious. If you cannot really, they should speak with one voice. You cannot end criminality if you're not committed to put your money where the mouth is. And so far, Matlala Commission has been proven to be the best ever commission of inquiry, because every person that's implicated in that commission of inquiry ended up being arrested. Yeah, ended up being arrested, all of them, and all of them are rotting in jail as we speak. So we are not this stuff with the IDAC. It's a problem. IDAC has become an obstructionist rather than an anti-corruption organization. IDAC itself as an organization. So yeah. Anyway, I'm just gonna play these videos that to show you that how implicated Matlala is in this stuff. Just like a few days ago, when they were still working out this stuff, Matlala, there was more stuff that implicate Matlala and his partner, business partner, Mark van Wyk. Let's have a listen.
We then come to one of the more important chats, and this one requires a fair amount of contextualization, because what the evidence leaders will be submitting in this regard is that is evidence of Mr. Matlala and Mr. van Wyk involved in the dealing in cocaine. The starting point is at page 378. Sorry, well, let's start. Mr. van Wyk, at 3.6 of his notice, was asked to address the exchange of messages on 6 April 2025 from 10:25 to 10:48. And if we go to those messages, the starting point is a video that appears at the foot of 377 and the top of page 378, and we need to play that video.
Let's talk. Namanya matatu fikin sendela wala ni na. So one so much. Na only 9 something 970. still total. Yes. Yeah, it's still big.
Now, if we go back to page 378, we'll see that that video was sent by Mr. Matlala to Mr. Van Wyk. I should at this stage just record, although I will address it in more detail later, that Mr. Van Wyk disputes receiving this video. But the chats reflect that it was sent from Mr. Matlala to Mr. Van Wyk at 10:25 on the 6th of April. At 10:26, Mr. Matlala sent Mr. Van Wyk a message saying, "Get me a good price." And at 10:31, Mr. Matlala, Mr. Van Wyk replied with a voice note, which we will play now. You're having a problem with the voice note, it's quite important. So we've listened to it several times. It says we'll go in at 2:50.
Do we know whose voice that is?
We don't know for certain whose voice that is. We would like to ask Mr. Van Wyk whose voice that is, and in particular whether it's his.
Mr. Chaskasen, you say Mr. Van Wyk disputes receiving that video.
Yes.
Where does he do that in his statement? Where do we find that?
He does it in his statement at page 17, paragraph 6. Where he says, "Once again, I received the video recording from the inquiries I made to the Commission and confirm that I never received this WhatsApp video on my cell phone."
Thank you.
But to go back to the sequence, we see back on page 378, after that voice note, at 10:36, there is an audio call from Mr. Matlala to Mr. Van Wyk. And then at 10:48, Mr. Van Wyk forwards to Mr. Matlala what appears to be a message sent to him by a third party. "Mike, we're ready to take tomorrow afternoon, has got important engagement in the morning 1. Wednesday we can take 2 again." We understand that video to be referring that note to be a message sent to Mr. Van Wyk referring to the bricks of cocaine that were being weighed out on the video. We'll get to why we say it's cocaine shortly. And Mr. Van Wyk forwards that note to Mr. Matlala at 10:48, and then there is a voice call at 10:49.
Just for the record, why do you say this appears to be a forwarded message?
No, that we can show that it's a forwarded message, because on the the extraction report of Mr. Matlala's phone will show that that message is forwarded.
Thank you.
To understand the full chronology, one needs to look at Mr. Matlala's chats with a third party who, for now, will remain nameless. And those chats are reproduced from page 542. And why we knew to look at these chats is that we found the same voice note saying we'll go in at 2:50, the identical file in these chats. Those chats start earlier than the chats between Mr. Van Wyk and Mr. Matlala. And they start with a call on the 6th of April, the same day, at 7:48 in the morning. Following the call, there is a deleted message at 7:49. We've established that that deleted message was the video that we see in the chats between Mr. Van Wyk and Mr. Matlala, and we've established that from the third party. At 7:50, there is another call. At 7:52, there is another call. Then the third party sends Mr. Matlala a screenshot of the third party's exchanges with some other people. And those exchanges start with 100% at the top, or 100 at the top at 9:07 in the morning. Then the fourth party, we shall call him, or her, says, "Are you winning?" The third party says, "I'm waiting for him to come back, but he said 350K, it's too much." The fourth party says 300. At 9:25, Mr. Matlala says to the third party, "Okay, I'm also getting good price, so you can make profit." Third party sends a thank you emoji. And at 10:22, Mr. Matlala says, "How many bricks you have?" There's then a call at 10:32. But to go back to the chronology, before we get to the call at 10:32, the video to Mr. Van Wyk is sent at 10:25. So after Mr. Matlala says to the third party, "How many bricks you have?" he sends the video to Mr. Van Wyk at 10:25. And if we can just play that video again. There is something on that video that I want to draw attention to. Can you stop and say, "Hey"? That's good. So it's evident throughout the video, but these bricks actually are branded. They say prestige on them, and they have a crown symbol on them. And we asked the SAPS if they were aware of any narcotics that are branded in this fashion. And we received an information note from Brigadier Allen, who is the section head of chemistry in the SAPS, and that information note appears at page 752. And if we go to 752, we'll see the information note. It explains the background, and it is signed by Brigadier J. Allen, Section Head Chemistry at 758. For present purposes, we would ask the Commission to focus on the information note from paragraph 3.25. And there Brigadier Allen says, he explains that the images were sent to his department originally, through SAPS head office, having received them from the Commission and what the Commission's inquiry was. And then at 3.25, he says, following the circulation of the images in the video to all the SAPS forensic science laboratories that perform drug analysis, feedback was received that such blocks with the indicated logo or imprint as depicted in the above included image from the video have indeed been received by the forensic science laboratory. The following drug-related case lab, the lab number and Boyson's case number is noticeable. Exhibit material in this case has been received for analysis by the Forensic Science Laboratory on 21 July 2025, and the analysis process has been concluded. Over the page, 3.32, in the specific case, 2 evidence sealing bags with seal numbers are given, were received together containing 6 blocks with a total weight of about 6 kilograms, each block weighing approximately 1 kilograms. Our video showed 5 blocks, each showing approximately 1 kilogram. The blocks were tested by Forensic Science Laboratory and have tested positive for cocaine. Of the 6 blocks, 3 blocks had the Prestige imprint as in the video, and the other 3 blocks did not have the same imprint. The following are relevant images of the blocks that were received in the specific case with the imprint clearly similar to the imprint on the blocks in the video material. Photos 3, 4, and 6. And then over the page on photo 3, one can see the block is now fragmented, but one can see the same crown symbol and the same Prestige imprint on it. And then again, there is, if one goes down to page 757 at photo 6, one sees the crown symbol and the Prestige stamp on it.
As you have heard, Matlala and Mike van Wyk are implicated again. And this video was just last week that was disclosed at Matlala Commission of Inquiry. Yeah. This is a person who's going to be a state witness and leaving the entire slew of the network of drug cartels untouched by this deal, IDAC deal, International Drug Syndicate, to thrive under this IDAC deal. It's a joke. Yeah. Like I said, a monster just walked into a courtroom and managed to negotiate a sentencing lower than what anyone who's been alleged to have done things like this would be able to get. And that this IDAC did just to get a few crook cops out under this deal. It doesn't work that way. As Glennis has said, it doesn't work that way. It's a crap. This one, the difficult pill to swallow. This IDAC stuff. I just don't think this institution gets it. That the public is really looking for leadership and looking for an institution that promotes safety above everything else. Promote safety.